Hello there. Steve here. Welcome back to another Sleepy Steve story. I hope you are tucked in, comfortable, and warm. Go on. Adjust your pillow if you need to. Let your shoulders drop, and allow the day to slow down around you, because there is absolutely no rush tonight. None at all. Before we drift off tonight, remember to subscribe to help Steve-O out. And I will keep making more sleepy stories to help you study gently, revise quietly, and settle your mind at the end of the day. We are beginning VCE Legal Studies, Unit 3, Area of Study 1, the Victorian Criminal Justice System. This is where legal studies becomes a little more exam-focused, a little more precise, and a little more concerned with how the system actually works in practice, because in Unit 3 we are not only naming legal ideas, we are explaining them, applying them to cases, and evaluating whether the system is able to achieve the principles of justice. Tonight we are going to move slowly through the foundations of the Victorian criminal justice system. We will begin with the purpose of the criminal justice system and why it exists in the first place. Then we will look at the difference between summary offenses and indictable offenses, because understanding the seriousness of an offense helps us understand which court may hear the matter and how the process might unfold. After that, we will revisit the presumption of innocence, the burden of proof, and the standard of proof, because these are not just Unit 1 ideas. They sit right at the center of every criminal case in Unit 3. Then we will quietly consider the main participants in a criminal case, including the accused, the prosecution, the judge, the jury, victims, witnesses, legal practitioners, and the court itself. And finally, we will keep returning to the three principles of justice: fairness, equality, and access. Because in Unit 3, students are expected to evaluate whether the criminal justice system achieves these principles during a criminal case. You do not need to write any of this down right now. You do not need to memorize every phrase. Just let the structure settle in your mind, because tonight we are building the foundation for the rest of Unit 3. Take a slow breath in and let it go. Imagine that we are sitting in a quiet study room late in the evening. There is a soft lamp on the desk, a legal studies notebook open in front of us, and beyond the window, the street is dark and still after rain. The footpath outside reflects the glow of the streetlights. The trees move gently in the night breeze, and somewhere far away, a car passes quietly and then fades into the distance. This is the kind of night where study does not need to feel sharp or stressful. It can feel calm. It can feel steady. It can feel like placing ideas carefully on a shelf, one at a time, knowing that each idea has its proper place. So, let's begin with the purpose of the criminal justice system. The Victorian criminal justice system is used to determine whether an accused person is guilty of an offense, and if guilt is found or admitted, to impose an appropriate sanction. That sentence is important. So let's move through it slowly. The system determines guilt. That means it is not supposed to begin with punishment. It is not supposed to begin with assumption. It begins with a charge, with an allegation, with the claim that a person has committed a criminal offense, and then the system must determine whether that allegation can be proven. In a criminal case, the accused is the person who has been charged with an offense. The prosecution represents the state, and it is the prosecution that brings the case against the accused. This is because criminal law is concerned with behavior that is considered harmful to society as a whole. even when there is also a particular individual victim. If a person is assaulted, or property is damaged, or something is stolen, the immediate harm may be experienced by one person, or one family, or one business. But the criminal law treats that behavior as a wrong against the wider community. That is why the case is not usually called one private person against another private person. It is the state against the accused. The system asks whether guilt can be proven, and if guilt is proven, or if the accused pleads guilty, the court then considers the appropriate sanction. A sanction is a penalty imposed by a court on an offender. But we will come back to sanctions in another episode, because tonight we are simply setting up the system, noticing its purpose, and understanding the path that a criminal case begins to travel. Take another slow breath in and gently let it out. Now, let's think about criminal offenses. In legal studies, you need to understand that not all criminal offenses are treated in exactly the same way, because some offenses are less serious, some are more serious, and some are so serious that they must be heard in higher courts. A summary offense is generally a less serious offense. Summary offenses are usually heard and determined in the magistrate's court, and they are generally decided by a magistrate without a jury. Examples might include minor driving offenses, minor property damage, or other less serious criminal matters, depending on the particular law involved. The word summary suggests a process that is more direct, more contained, and usually less complex than the process for serious indictable offenses. An indictable offense is generally a more serious offense. Indictable offenses may be heard in the county court or the Supreme Court, and serious indictable matters may involve a judge and jury, especially when the accused pleads not guilty and the matter proceeds to trial. Some indictable offenses can be heard summarily in the magistrate's court if the law allows it and if the circumstances make that appropriate. But as a broad distinction, summary offenses are less serious and indictable offenses are more serious. Hold that distinction gently. Summary, less serious, usually magistrate's court. Indictable, more serious, may be heard in the county court or Supreme Court. This distinction matters because the type of offense affects the process, the court, the possible sentence, and the level of complexity involved. Now, as the rain taps softly against the window in our quiet study room, let's return to one of the strongest ideas in the criminal justice system: the presumption of innocence. A person accused of a crime is presumed innocent until proven guilty. That means the accused person does not begin the case needing to prove that they did nothing wrong. They do not have to earn innocence. They do not have to win innocence back. The legal starting point is innocence, and that starting point remains unless the prosecution proves guilt according to law. This is a vital protection because criminal accusations can have serious consequences. They can affect liberty, they can affect reputation, they can affect family life, employment, education, mental health, and standing in the community. Because the consequences are serious, the system places the responsibility on the prosecution to prove the case. This responsibility is called the burden of proof. In a criminal case, the burden of proof rests with the prosecution. The prosecution must prove that the accused committed the offense. The accused does not generally need to prove innocence, and the prosecution must prove the case to a very high standard. That standard is beyond reasonable doubt. Beyond reasonable doubt does not mean beyond every possible doubt, because human life is complicated and almost any situation could involve some imaginary or unreasonable doubt. But it does mean that the court or the jury must be satisfied to a very high degree before the accused can be found guilty. If there is reasonable doubt, the accused must be found not guilty. Let that idea rest for a moment. The accused is presumed innocent. The prosecution carries the burden of proof. The standard is beyond reasonable doubt. These three ideas work together like a quiet triangle of protection. They are not decorative ideas. They are not just words for a glossary. They shape the way the entire criminal justice system is supposed to operate. Now, let's think about the courts. Victoria has a court hierarchy, which means courts are arranged in levels, and each court has its own jurisdiction. Jurisdiction means the lawful authority of a court to hear and decide particular types of cases. In the criminal justice system, the magistrate's court hears summary offenses and some indictable offenses heard summarily. It also deals with many preliminary stages of criminal matters, such as bail applications, mentions, and committal proceedings for some serious offenses. The county court hears most indictable offenses, except for the most serious offenses, and it may conduct criminal trials before a judge and jury. The Supreme Court, particularly the trial division, hears the most serious criminal offenses, such as murder, and the Court of Appeal can hear appeals from lower courts on certain grounds. So, when you think about the criminal court hierarchy, imagine a gentle set of steps. The magistrate's court at the lower level, dealing with less serious matters and early stages. The county court above it, hearing many serious indictable matters. The Supreme Court above that, dealing with the most serious matters and significant appeals. This hierarchy supports the operation of the criminal justice system because it allows cases to be heard in courts with the appropriate authority, experience, procedure, and seriousness. It also allows for appeals, which can be important when a party believes that an error has occurred or that a sentence or conviction should be reviewed according to law. But remember, an appeal is not simply a second chance because someone is unhappy with the outcome. Appeals usually require legal grounds, such as a question about the application of the law, the fairness of the process, the conviction, or the sentence. Now, let's slow our breathing again. In and out. In and out. The lamp on the desk is still glowing softly. The notebook is still open. And now that we understand the broad purpose of the system, the types of offenses, the standard and burden of proof, and the basic court hierarchy, we can turn to the people within the system. A criminal case is not only a set of rules, it is also a process involving people, each with a role to play. The accused is the person charged with the offense. The accused has rights, including the presumption of innocence, the right to a fair hearing, and the right to legal representation, although the practical ability to access representation may depend on resources and availability. The prosecution represents the state and carries the burden of proving the case beyond reasonable doubt. The prosecution must present evidence and arguments to establish that the accused committed the offense. The defense lawyer represents the accused and helps protect the accused's interests by advising them, testing the prosecution case, making submissions, and ensuring that the accused receives a fair process. The judge or magistrate manages the hearing or trial, applies the law, makes rulings on legal issues, and in some cases determines guilt or decides the appropriate sentence. Where a jury is used, the jury listens to the evidence, follows the judge's directions, and decides whether the accused is guilty or not guilty based on the facts. The victim may give evidence as a witness, may be affected by the outcome, and may have certain rights and supports within the system. Witnesses provide evidence about what they saw, heard, experienced, or know. Court personnel, interpreters, support workers, police, corrections officers, and legal aid services may also play important roles in helping the system operate. Each participant has a role. Each role affects the process, and when those roles are performed properly, they can help the system move closer to fairness, equality, and access. Now, those three principles are central to Unit 3. Fairness means that people should have a fair and impartial process with a reasonable opportunity to know the case against them, present their side, test evidence, and have the matter decided according to law. In a criminal case, fairness may be supported by the presumption of innocence, the burden and standard of proof, legal representation, the right to silence, the right to a fair hearing, and the right to have the matter heard by an independent and impartial decision-maker. But fairness may be limited by delays, stress, complexity, the cost of legal representation, difficulty understanding legal language, or the emotional pressure of going through a criminal process. Equality means that people should be treated equally before the law, without unfair discrimination, and with recognition that some people may need additional support to participate on equal terms. In criminal cases, equality can be supported by interpreters, legal aid, culturally appropriate court processes, support for vulnerable witnesses, and procedures that aim to reduce disadvantage. But equality may be limited when people have different levels of money, education, confidence, language ability, disability support, community support, or understanding of the legal system. Access means that people should be able to understand and use the legal system, including being able to obtain information, advice, representation, and support when needed. In criminal cases, access may be supported by Victoria Legal Aid, community legal centers, duty lawyer services, interpreters, victim support services, online information, and court assistance programs. But access may be limited by cost, delay, distance, language barriers, lack of knowledge, fear of the system, or limited availability of legal services. So when you are answering Unit 3 questions, it is not enough to simply say that the system is fair or unfair. You need to explain how particular features of the system support or limit fairness, equality, and access. For example, the right to legal representation can support fairness because it helps an accused person understand the charges and respond properly to the prosecution case. It can support equality because it may reduce the disadvantage faced by someone who does not understand the legal system. It can support access because it helps the person participate in the case. But if legal representation is too expensive or legal aid is not available, then the same issue can limit fairness, equality, and access. This is the kind of balanced thinking Unit 3 requires. Not just definitions, not just lists, but explanation, application, and evaluation. Let's pause here for another breath. Slowly in and slowly out. Now, It is helpful to think about the criminal justice system as a sequence, even though every case does not follow exactly the same path. A criminal matter may begin with investigation. Police may gather evidence, speak to witnesses, question suspects, and decide whether a person should be charged. If a person is charged, they may need to appear in court. The court may consider bail, which is the release of an accused person from custody while they wait for their case to continue, usually with conditions designed to manage risk. If bail is not granted, the person may be held on remand, which means they are held in custody before their matter is finally determined. Some cases may involve committal proceedings, which are used for some serious indictable offenses to determine whether there is enough evidence for the accused to stand trial in a higher court. There may be plea negotiations where the prosecution and defense discuss whether the accused will plead guilty to certain charges, possibly in exchange for other charges being withdrawn or changed, depending on the circumstances and the interests of justice. If the accused pleads guilty, the matter may move to sentencing. If the accused pleads not guilty, the matter may proceed to a contested hearing or trial where evidence is presented and guilt is determined. This sequence matters because pre-trial procedures can affect the principles of justice. They may support fairness by clarifying issues, testing evidence, and encouraging early resolution. They may support access by helping parties understand the case before trial. They may support efficiency by avoiding unnecessary trials, but they may also create challenges, especially if the process is slow, complex, costly, or difficult for the accused, victims, or witnesses to understand. Again, Unit 3 often asks you to think in both directions. How does a feature help the system achieve justice? And how might that same feature or its practical operation limit justice? Now, let's come back to sanctions, but only briefly, because they will be the focus of a later episode. If an accused person is found guilty or pleads guilty, the court must decide what sanction is appropriate. The purposes of sanctions include punishment, deterrence, denunciation, protection, and rehabilitation. Punishment means imposing a penalty that reflects the seriousness of the offense. Deterrence means discouraging the offender and others in the community from committing similar offenses. Denunciation means showing the court's disapproval of the offending behavior. Protection means protecting the community from further harm. Rehabilitation means helping the offender address the causes of offending and reduce the chance of reoffending. Common sanctions include fines, community correction orders, and imprisonment. Each sanction may achieve some purposes better than others. A fine may punish and deter, but it may not affect every offender equally. A community correction order may support rehabilitation while allowing the offender to remain in the community, but its success may depend on compliance, supervision, and available programs. Imprisonment may punish and protect the community by removing the offender for a period of time, but it is expensive and does not automatically rehabilitate. In Unit 3, you need to evaluate the ability of sanctions to achieve their purposes, not just name the purposes. That means thinking about strengths, weaknesses, examples, and real-world limitations. For tonight, though, we only need to place sanctions on the map. They come after guilt. They are imposed by courts. They are legal consequences. And they connect to the wider aim of the criminal justice system. Now, as the room grows quieter and the rain outside becomes softer, Let's gather the whole episode together. The Victorian criminal justice system is used to determine whether an accused person is guilty of an offense, and if guilt is found or admitted, to impose an appropriate sanction. Criminal cases involve the state and the accused because criminal offenses are treated as wrongs against society. Summary offenses are generally less serious and are usually heard in the magistrate's court. Indictable offenses are generally more serious and may be heard in higher courts, such as the county court or Supreme Court. The accused is presumed innocent until proven guilty. The prosecution carries the burden of proof. The standard of proof is beyond reasonable doubt. Victoria's court hierarchy helps allocate cases according to seriousness and jurisdiction, and it allows for appeals where there are proper grounds. The criminal justice system involves many participants, including the accused, prosecution, defense lawyers, judges, magistrates, juries, victims, witnesses, police, and support services. And throughout every stage of a criminal case, we keep asking whether the system achieves fairness, equality, and access. Fairness asks whether the process is impartial and gives people a proper opportunity to participate. Equality asks whether people are treated equally before the law, with support where needed to reduce disadvantage. Access asks whether people can understand and use the legal system, obtain advice, and participate meaningfully. These are the ideas you will keep returning to in Unit 3. They are the threads running through criminal cases, civil disputes, sanctions, remedies, courts, tribunals, and dispute resolution methods. You do not need to hold all of this tightly tonight. Let it soften. Let the terms settle. Criminal justice system. Accused. Prosecution. Presumption of innocence, burden of proof, beyond reasonable doubt, summary offenses, indictable offenses, magistrate's court, county court, Supreme Court, fairness, equality, access. The lamp on the desk is still glowing. The notebook can close now. The rain outside can continue without needing your attention. Your study for tonight is done. You have begun Unit 3. You have placed the first ideas carefully in order. And now, as your breathing becomes slower and your body becomes heavier, you can let the Victorian criminal justice system rest quietly in the background of your mind, ready to be returned to another night. This has been Sleepy Steve helping you fall asleep and study. Rest easy and sleep well. Good night.